We are discussing about codification and what are benefits or merits of codification. That merits of codification is that it makes the law certain. It makes the law easy to accept by other countries also. For example, if the law, international law is certain in nature, then it will be easy for the different countries to accept that particular law or adopt that law in their in their domestic system also. So that will make it easier for them because if that law is certain in nature. So it is not like that only merits are there. Some demerits we can also identify through uh, while reading many documents. You will find that it is not quite easy to amend international law because in our domestic law, in constitutional provisions are provided that by way of some simple voting process or simple. Somebody's mic is on. Please switch off your mic while सभी की माइक ऑफ है. Yeah. So the amendment process in particular international law is difficult process because we in that particular, for example, for creating international law or for creating some convention or treaties on international law, we first have to bring so many countries together. We have to discuss so many things in General Assembly. देखिए एक बात मैं कहना चाहता हूँ, जिसको क्लास करना है अगर डिलीजेंटली करना चाहता है तो क्लास करे, अदरवाइज कोई मुझे कोई प्रॉब्लम नहीं अगर वो क्लास नहीं करेगा तो मैं अटेंडेंस दे दूंगा उनको. ये बीच में डिस्टरबेंस अगर आप क्रिएट करोगे मैं आपको आउट कर दूंगा, क्लास लॉक कर दूंगा. ये सबके लिए है. नहीं पढ़ना है मत पढ़ो, मेरा समय मत बर्बाद करो और बाकी लोगों का भी. So the process of amendment. So you will see that if you take into consideration some international law, you will find that whenever some law, some changes they required, what they do, they add additional protocol in this particular law. For example, if you take the ICCPR, International Convention of Civil and Political Rights, you will find there are two additional protocols are added. And they at that particular additional protocol, some are still not effective in nature. So the process of development is an as a difficult task in international law, as well as changing law in the international law is also difficult. It is not like some established principle is there and you have to codify that and that the end of the process. It is not like that. Few more changes can be in the possibility of changes can be there. So in that way, the amendment process is also difficult. So quite the codification gives certainty to the law. Codification gives the easy access to some nations so that they can easily adopt that law. But codification also gives rigidity to the law. Rigid law you can't change. So in that case, you need to have some additional protocol related to that. एक मिनट, मैं एक मिनट एक Hello.
Yes, sir, you're audible.
Sorry, actually, some student has come. There was some issues in results, so she was discussing with me. So,
No issues.
so basically, we are discussing about that. Oh, it is the process of development of international law, which we have till now understand the concept. That we till now we have basically understood the concept related to how the international law developed in or the evolution of international law. But when we look into the exact position how the international law, the laws related to international law developed, then we have to look into the sources of international law that we will discuss in the next unit or next chapter. So the sources we will discuss how the international evolved, what are preemptory norms, what are just cogents. So we will discuss that part only. So till now we are discussing about development of international law, and in during that development, one very important phase come into picture, that is codification of international law. Because till now we are discussing only international law in a view of that some theories, but when we have to certain that law so that every individual can have access to that law, or every individual can have, every state have the certainty about what they are adopting in real nature, so we have to move forward to codification. So codification gives certainty, but with that certainty some rigidity also come into picture, and for that there is a need of changing that particular mechanism how that law should be, because it is not easy to convince 193 countries again and again to discuss some issue. So the process, it also take time. The reason is that the creation of international codification of international law, like till now there is a sixth that international law commission committee is there, and what they are discussing right now, they are right now discussing customs, whether we have to, how we make customs as certain. So how customary international law, it already in history how customary international law evolved, but they are trying to make certain that to make certain the customs. So they are working on that part. When you visit the that particular website of international law commission through United Nations website, you will find that what they are currently working. So you will find what that they are working right now on topics related to customs. So I was visiting, and they are basically compiled a draft articles relating to that. So process, that means the codification is not also quite easy. It take time, and due to that reason, some amendments will also take more time. So to convince people to be part of that particular discussion, so that will basically have can be a problematic issue. So codification merits are also there, and in a way we can say there are demerits are also there. So now we move forward that what is basically the role of International Law Commission. So International Law Commission was established in 1947. United Nations was established in 1945, and International Law Commission was established in 1947 by the General Assembly, and it was for promoting it was basically for promoting progressive development of international law and codification. That means they have used the word. The objective of International Law Commission was that uh, that to basically develop, and that development should be progressive in nature. They have used the word progressive. That means they want to evolve that the evolution process. They basically enhance the whatever process is going on. They want to basically progressive in nature. So 1947, they have established International Law Commission, and the role of that particular commission is to codify, first of all, identify areas where they can create laws, first of all, and then codifies that law. So codification, what they do, they basically do, they make a draft articles. They basically have a draft um, treaty, and that treaty should be presented to General Assembly, and after that they discuss with different countries, and if they want, they can adopt that particular thing, or they will bring some convention regarding that. They will ask some convention or some treaty signing process will be there, so they adopt that particular treaty. So this is the process. They, first of all, they have to identify they that what area they can work on. So they have, this is the first thing about the this particular International Law Commission. Now the total member who are part of this particular International Law Commission are 34. That means 5 from each, we can say, continent. Africa, Asia, America, Europe, and Australia is also there. So they have considered that in the same part. So they are in this particular 34 nations are there, and these 34 nations are for this, the time period is for 5 years. They will be there. They will discuss in 5 year different laws, international law. They will draft different articles, and they will submit those articles to the General Assembly. So this is the basically the work of International Law Commission. So International Law Commission main work is to identify areas where they have to work on international law. For example, in some areas of law where there is no international law is there, and when they identify that law, they will work on that particular law. They have the members from different, these 34 members are from different continents. The reason is that they are from different continents is that they have to make law for the whole world. So these all 193, for example, there are 193 members are in United Nations. So they make law for each and every nation, so that they can easily adopt that law in their domestic system, or they can easily follow that law in international system also. So they need members from each and every corner of this world. So this is, so they have divided this 34 requirement of members is due to that reason only, that in the for, and they are working for 5 years. It is not like the tenure is for 1 or 2 years. They give proper time period. The 5 year is a good time to discuss, to create, or to have a brainstorming session on every law. So they basically give this type of benefit to the member country, that they become, it is like that. So, and other bodies also support this International Law Commission. How other bodies, which are other bodies which support this? The first is Asian African Legal Consultative Organization or Committee. The second is the European Commission on Legal Cooperation. And the third is Inter-American Council of Jurists. So three bodies. First is Asian African Legal Consultative Committee. The second is European Commission on Legal Cooperation. And the third is Inter-American Council of Jurists. So these three bodies are very much important. ALCO, one is Asian African Legal Consultative Organization, which headquarters is in Delhi. So they discuss, they basically have the people from Asia, that means from China, Japan, India, and from African countries. And it is also, we can say, is basically recognized by the United Nations, this body. And the another is that European Commission of Legal Cooperation and Inter-American Council of Jurists. So International Law Commission is supported by these three regional legal cooperation. For example, the ALCO, the American Inter-American Legal Council, or European Council, European Union Legal Council. So these committees basically help International Law Commission to create laws, to make laws in some different areas. For example, if it is related, if they are making law, so ALCO will support it from the knowledge, whatever knowledge they have for Asia and Africa. For example, America will guide them for American law. For European Union will guide for European Union. So this is the basically these committees, these we can say regional committees, legal committees also help International Law Commission. Now, most of the important international convention have grown out of the commission's work. So they have different thing. They basically prepare a draft and they submit to their various states for comment. And after that, they basically submit to the General Assembly. So you can basically you will look into that. International Law Commission has diverse work. They basically compile work related to maritime issue. They basically draft Rome Statute. They will draft the rules regarding the that particular international criminal code. So the first international tribunal which was created in 1945, that this particular they have guided. Before that it was not established in official form, because it was established in 1947. So they have also guided for creation of this IMT, the law of the sea in 1958, diplomatic relation rules regarding in 1961, consular relation in 1963, special missions in 1969, and law of treaties in 90. That means the VCLT, Vienna Convention of Law of Treaties, also drafted by these International Law Commission people. So International Law Commission have diverse role because they work in every area of international law, whether it is maritime, whether it is criminal law, whether it is refugee law, whether it is for consular access, for example, the or whether related to immunities provided to the embassy people. So they work on every each and every area of law. They basically work. They basically take out they basically take out from which area the work is the international law have not worked, and they basically try to look into this particular part, and they try to make law on that particular and they discuss with the states also. It is not like that they only discuss with that people who are representative. They basically send their draft to the states, and the states give comment on that particular draft, and after taking the comment of the all state, they basically whether the if the comment is good in nature and it should be if that particular thing can be adopted, they look into that and they adopt that particular thing into their treaty also, whatever the draft treaty they have made, and after that they submit that draft treaty to the General Assembly. So this is the process how the International Law Commission basically work and guide the particular development. So this is they have worked in a way. They have basically uh, drafted many important things in relation to the International Law Commission, whether it is related to, which I have already said, that whether it is related to uh, for example, the creation of International Criminal Court, Rome Statute, which we say. So Rome Statute also, that particular rules and regulations were drafted by this. And most of the time what happened, even though these treaties are in draft nature, sometime International Court of Justice refer this treaty, the draft treaties of this particular, because they go through the treaties and they basically support these treaties. So International Court of Justice basically refer these while they are giving judgments regarding different issues. They refer this particular uh, draft treaty in their judgment also. So this is the importance. This is the importance of this particular all draft treaties. So draft treaties are, it is not it is, we can say it is also one of the important source of international law, because during the International Court of Justice, while they decide judgment, they use this as a part of their judgment also for referring some important points. So this is the importance of International Commission, how International Commission has evolved in a way, and they are working on different issues. If you visit their site, you will find that they are working on different issues at the same time. So you can have idea that how much knowledge they have about the particular thing, how much energy they give to this particular things, because they want, they have to send this each and every draft uh, treaty to different states also. So they have to be more sincere for their work, and whatever effort they are giving to that particular um, treaty making, we can say, is very important job they are basically doing. So we have to basically it is one of the important pillar of international law, that International Law Commission is supporting this in a way. So now we'll move forward. So this is about the International Law Commission. Till you have any question regarding this particular topic, International Law Commission? We will go more in this particular topic during we will discuss the treaty as a source of international law, because in that particular topic we will discuss VCLT also, some little bit idea of important articles of VCLT, Vienna Convention of Law of Treaties, and some work of that International Law Commission also. So you have any question regarding this, anyone?
No, sir.
So you are so now we move forward to the topic, which is relationship between national law and international law. So it is quite easy. Some place you will find domestic law, some place you will find international law. So that particular the national and this particular domestic law is similar in nature. So we will have to look into now uh, that relationship. Now, why there is need to understand this concept? Anybody can answer? Why we need to identify? These are two different things. Why we need to identify these two things? Why there is need to establish a relationship between national law and international law? Is there any reason? Perfect reason I want
Just,
from you that yes.
so that they have like harmony between them and they don't like uh, uh, get in conflict with each other, like laws.
Yes. So it should be like that if you have the idea that what and how there is a relationship between national law and international law, that you can avoid conflict. As Rudra Abhishek has said, that it will be easy for us to basically avoid conflict, and because if there will be conflict, because domestic law is basically established field, nobody is going to challenge that thing, but everybody is going to challenge international law. Because why they will challenge international? Because international law, I'm talking about that period. For example, after the creation of United Nations, many people have no faith in United Nations. Still, many people are saying that there is something missing. I am also supporting that view that international law have something, because if the only question is that the the sitting arrangement of this particular security council, each and every individual who is in, for example, who is Indian, basically who is basically citizen of India, will support my view that we must have a position in security council. That means permanent, not position. That should be the permanent. That position should be there. That we should be permanent member of security council. This is the particular view, because it is very we can say only 5 countries are permanent member, and they are basically what they are doing. They are dominating all the process of international law. They are looking into that what is in their favor. They only discuss that thing and they don't go into different things. So in a way we can come into that particular thing, that even we consider international law as a strong law, or it is beneficial for the whole human civilization, but we have to look into that fact also, that we need some equality. What the equality principle which Vettel has given in the past, that all states are equal in nature, we are not finding that in our present United Nations concept. All nations are not equal in nature, because that particular that 15 members are in security council and only 5 members have that particular veto power. So that particular thing can basically a difficult thing in the international law that you can't avoid. It is there, and we are basically facing that issue here and there everywhere, in different issues. So we'll not go into that particular point, because we will when we will discuss the security council, we will have an idea about this particular thing. Now, when I am talking about relationship, that relationship is basically on the basis of two important theories. Two important theories are monism, that is monistic theory, and dualism, that is dualistic theory. So now what is monism theory? That means monistic, that means monistic come from word mono. Mono means single. That means they are saying that international law and national law, that means international or national law, have common origin. These two laws are common origin. So this is monistic theory. Mono means single, and monistic, that means monism. We say that international law and national law have common origin, single origin, we can say. So by way that we can understand the concept, whenever you will find the word monism, monism means single origin, and single origin, that means these two different laws, national as well as international law, are working in same arena, same field, and have single origin. So it is not two legal system, but they are one single legal system in there. So monism means this. Mono means single legal system. That means national law and international law are working in single legal system. There is no different origin of this particular law. So this is the first theory of relationship between national law and international law. You will be able to understand the concept. First, monistic theory, you are able to understand. All monistic, monism, that means single origin. Single origin, that means international law and national law have common origin, and they are working in same area. They are basically, the system has not, no different system is there. They are working in same system. So this was propounded by two people, that was Moser and Martens. Moser and Martens are basically, the monistic theory was propounded in 18th century by these two people, Moser and Martens. Name Moser and Martens. Monistic, mono, single origin. Quite easy to understand. You can write in your own words. No need to mug up this whole thing. You can easily understand the concept that this particular theory, that is monistic theory, that international law and the international law, and there is no distinction between local law, that is domestic law, national law, and international law. Those who adopt this theory assume that the philosophy of law and the law are common law, which is universal law. That means whatever law, domestic law is there, that particular law is also universal in nature. So this was the concept of the monistic law. Moser and Martens has propounded this theory. So their basic belief of this theory is that domestic law is no different with international law. International law is no different with domestic law. If you are adopting international law, for example, it is part of your system, so it is domestic law. And if you are supporting domestic law, it is also international law. So they're trying to convince that these two laws are similar in nature. Mono means single, and these two law are single in nature. So this is the basic concept which basically monistic theory has provided. The second theory, which is dualistic theory, dualism, the those people who supporting this theory of dualism, that say that there is a difference between municipal law and international law, and these two laws have no equal intent. That means dualism means dual means though means, that means the theory have two different origin. The say that national law and international law have two different origin, and they are not working in same. They are, first of all, they are different. They are different in nature, and they work on two different system. One is working on international legal system, and second is working on national legal system. So these are basically the two concept or two theories regarding the relationship between national law and international law. So the dualistic theory was propounded by Triple, and that particular monistic theory was propounded by that Moser and Martens. So these are Moser and Martens monistic theory, and Triple the dualistic theory. So this is basically the concept related to the relationship between national law and international law. And the two important theories are monistic theory and the dualistic theory. Monism and dualism. Dualism say that the two different origin, national and international law, and they are working in two different legal system. This is quite right in a way we can say. And monistic theory say that, it's monistic theory say that monism, that means they are working in same area, they are of single origin. There is no difference between international law and national law. So this is basically the, you have, I think, have quite easily understood the concept related to this monism.
Yes, sir.
You have any question regarding this?
No, sir.
No, sir.
No, sir.
Question. So now we have to look into this particular concept by way of two important philosophers. The first is Lauterbach and the another is the Kelsen. So how he have basically discussed the concept related to monism. So he said that there is two branches of law science, national law and international law. They describe the supremacy of international law over city law, whether national or international law, whatever legal work we deal with, international law itself will to be done. What is Lauterbach's view on monistic theory? Lauterbach claimed that the country lives by itself, the people are the fundamental components of society. Municipal legal structure, right and obligation can pass into the international legal system. For example, human rights are available in both national and international jurisdiction, so that national law and international law are not identical in the sense both national and international law obligations are aimed at promoting interest of the people. So he basically wanted to say that monistic theory, he basically supported the concept of monistic theory. He said that there can be chances where the two laws are working differently in two different legal systems, but the main aim of that particular law is to promote that particular law. For example, if you take the concept, what he has basically have given example, that if you take the example of human rights, you will find laws related to human rights. The NHRC is there, National Human Rights Commission is there, and there is an International Human Rights Council is there. They are basically there before 2005, I think they have commission, but after that they have changed it to council. So that particular, these two are two different they legal system. Human rights, National Human Rights Commission is for state, and the Human Rights Council is for international law. So, but both what they are doing, the objective of both this particular legal system is that to promote international or to promote human rights, whether it is national or international human rights, don't have to look into that. But the basic aim, he tried to convince that whether even though that particular monistic theory is there, it says that there can be a type of law which can be available in two different legal systems, but they are basically doing something, or they are basically projecting some objective which is the objective of both laws, whether it is national law or whether it is international law. So human rights is one of the very good example of particular the theory which basically want to promote. That the latter past view was on monistic theory is that even though the system is working in two different way, even there is distinct system, two different system, but the main objective of that system is to work in a way that to achieve the same goal. So he want to basically convey that monistic system also work in that way, that monism say that international law and national law have common origin, they are working in same system. So he tried to convince that even though they are not working in same system, they are trying to promote that particular common objective, they're trying to achieve that common objective. So this is one of the view of the latter past that he tried to convince that किसी का माइक ऑन है भाई off हो गया. So now another view of very famous person, and we all know him from jurisprudence time, uh, from studying jurisprudence, is the Kelsen, the propounder of pure theory. He said the principle he points out is that in accordance with the state legal system, one should envision international law as a single set of rules, just as one used to treating the state legal system as a unit. That he said that we have to treat international legal system same as a unit of domestic legal system also. We have to basically have that particular type of view. Many who do not follow this theory argue that municipal law does not comply with international law, and it seems like current historical conditions are making more difficult to enforce new rules. Ultimately, Kelsen notes that it is source of ultimate legal power of all the laws based on international law fundamental norms. His argument indicates that all international law principles are equivalent to local law. Municipal laws inconsistent with the international are regarded immediately as null and void and not applicable. So he tried to promote that particular the origin we have to consider these laws as uniform. But sometimes what happen in international law also, if you are not following that particular standard, for example, the example he want to the counter argument which basically the I want to give here, that he tried to convince that international legal system and domestic legal system we have to basically consider that at one time. But when you look into the concept, there is nowhere concept of peremptory norm in domestic law. Now, what is peremptory norm? I think I have discussed in earlier classes also, and I want to basically repeat that the same thing. Peremptory norm or just cogence principle. What is peremptory norm? When you look into the peremptory norm, it says that peremptory norms can be removed only by equal peremptory norm. That means if something is of that nature, just cogence principle, we say that you have to remove that just cogence, you need equivalent just cogence for that. Now, what is peremptory? That means a minimum standard that you have to follow in international law. So what happen if you are not following that? Even in domestic law, for example, you can't breach human rights, even you are party to United Nations or not. There will be action on that because it is peremptory norm. You have to follow some basic human rights you have to follow. So peremptory norm is very much important. So whatever Kelsen has tried to convince, that we have to basically envisage that we have to basically identify that domestic law and international law are similar in nature. We don't, his argument is basically we can't do that. Whatever he has said, that he is not right on that point, because sometimes what happen, in if something wrong is in domestic law, and if for then you have to, and that international law is good in nature in that particular topic, so you have to adopt that law. And if you are breaching that, you are basically breaching the peremptory norm. That means the basic standard. For example, no country can make can legalize slavery. No country can legalize slavery because it is below peremptory norm, because you have to maintain that standard. And if some country is doing that, if they are basically, what they are doing, they are breaching international law also. So creating some laws which are against human rights, which are basically totally avoided by the international committees or international people or international law, you can't implement that type of law. So Kelsen has tried to convince that international legal system and domestic legal system is one, to promote the concept of monism, but in few situations you can't adopt that thing. So there is exception related to that. In some time you can say that they are equal in nature, but you have to look into that, the just cogence principle, peremptory norms. These are the example. He said that municipal laws inconsistent with the international law are regarded immediately as null and void. That means if particular, for example, if India today started that from today onwards we will basically legalize the trade of humans or human trafficking, whether that will be part of international law, whether the international law will promote that particular thing, no, because that is against the peremptory norms or just cogence principles of international law. We will discuss the just cogence principles also in deeply when we will discuss the this particular sources of international law. That just cogence give a minimum standard you have to follow, even though you are not party to the United Nations, you are member of the United Nations or other bodies, you don't have to be part, but you have to follow minimum international standard in this particular during the development of this particular laws, because there can be conflict of international domestic law, but in that particular conflict you have to look into that whether you are conflicting with the peremptory norms. If domestic law is conflicting with the peremptory norms, then the domestic law should be avoided. If it is regarding different thing, then the situation can be different. But if it is regarding just cogence principle, it is regarding peremptory norms, then at that time that particular the domestic law have to basically to be a null and void that particular topic. If it is related to slavery, legalizing slavery, it is related to legalizing human trafficking, so that can be different, because that is a basic we can say a basic standard which the international law asks every nation to follow, whether you are member to that or you are not member, because it is not like international law is there only on the basis of this particular United Nations. Some customary international rules are also there. So we have to look into that particular point also. So this is for this class. We will understand this concept more in a way when we will discuss the concept of UK. We will discuss the concept of India and US. So till now, this is for this class. If you have any question, you can ask me.
सर कैल्सन से पहले जो आपने फिलोसोफर बताया था उसका नाम एक बार बता दीजिए स्पेलिंग।
उनका नाम थोड़ा डिफिकल्ट है, लेकिन मैं बता देता हूँ। उनको अलग अलग नामों से बुलाया जाता है इनको, लेकिन लॉटर पैच ही बोलते हैं ऐसे। उनका नाम LAUTERPACHT है। मैं प्रोनाउंस तो लॉटर पैच ही करता हूँ, टी नहीं, टी साइलेंट रहता है इनका। तो हाँ, तो आपको जैसे प्रोनाउंस करना है आप कर सकते हैं।
सर मिल गया थैंक यू सर।
हाँ, तो ये है। बाकी मैं आपको यार मैं नोट्स आज भेजता हूँ। सॉरी, मैं यार बहुत ज्यादा ही इधर उधर दिमाग आजकल चला जा रहा है। कुछ अभी एफडीपी के एक्चुअली सर्टिफिकेट्स देना था हम लोगों को, आज फाइनली हुआ है, तो आज हम लोग रिलीज कर देंगे, क्योंकि बहुत लोगों के मतलब बाहर से लोग पार्टिसिपेट 45 लोग किए थे, तो उनका सारा प्रोसेस बैंक के थ्रू इतना मतलब जो उन्होंने वेरीफाई करना था अमाउंट को, तो आज वो फाइनली हो गया। तो मेरा सारा दिमाग शाम में उधर ही रह रहा था, क्योंकि एक बार वेरीफाई हो जाएगा। आज में सर्टिफिकेट हम लोग डिस्पैच कर देंगे। दैट मीन्स बाय वे ऑफ दिस शेयरिंग ऑफ ड्राइव, नॉट इन द फॉर्म ऑफ हार्ड कॉपी। तो फिर हम थोड़ा रिलैक्स हो जाएंगे। तो अब मैं आज आपको शाम में कुछ मटेरियल्स मैं आपको सेंड कर दूंगा। ऐसे जो मैंने बुक सेंड किया है उसको थोड़ा मोड़ा हल्का फुल्का पढ़िए। अगर कोई पोर्शन नहीं समझ में आता होता है, क्योंकि कभी कभी किसी के साथ भी हो सकता है, तो वो आप मुझसे शेयर कर लीजिए, हाईलाइट करके वो फोटो खींच के भी मुझे भेज सकते हैं कि सर मुझे ये चीज समझ में नहीं आया, क्लास में डिस्कस कर दीजिएगा। जो जैसे जो 10-15 मिनट का जो टाइम बचता है ना, हम लोग वो काम कर सकते हैं। तो अभी से पढ़ना शुरू कर दिए, नहीं कि एग्जाम के टाइम पढ़ेंगे। तो ऐसा मत सोचिए। जो बुक मैंने सेंड किया है अच्छी बुक है। एक दो बुक और मैं आपको फॉरेन राइटर की भेज दूंगा, क्योंकि वो इजिली अवेलेबल है इंटरनेट पे। लेकिन मैं सॉरी फॉर, मैं एच.ओ. अग्रवाल और एस.के. कपूर मेरे पास नहीं है सॉफ्ट कॉपी, तो मैं आपको नहीं सेंड कर सकता हूँ, जो कि इंडियन राइटर की है। तो अगर वो आप लोग के पास कहीं से है तो आप लोग खरीद लें। अदरवाइज फिर या तो मुझे बोलिएगा तो मैं उसके क्या बोलते हैं फोटो, मेरे पास बुक है तो मैं उसका स्कैन करके आपको हो सकता है मैं भेज दूँ। तो अगर आपको जो अगर जरूरत हो तो बोलिए, मैं स्कैन करके भेज दूंगा। क्योंकि अगर आप लोग ऑनलाइन अभी, क्योंकि खरीदना मुश्किल हो रहा होगा कोविड में, ऐसे ऑनलाइन डिलीवरी हो रही है लेकिन मुझे नहीं लगता कि सब जगह कर रहे होंगे अभी। तो आप लोग को अगर एचओ अग्रवाल मेरे पास है, मेरे पास एस के कपूर नहीं है, तो मैं एचओ अग्रवाल का अगर आप बोलोगे तो मैं आपको पीडीएफ दे सकता हूँ, मतलब स्कैन करके। देखिए हम पूरा डिटेल में कोई भी चीज को उतना नहीं पढ़ सकते हैं, क्योंकि हमें सिलेबस को भी देखना है। मैं ऐसा पढ़ाऊंगा कि आपको बहुत कुछ ऐसा नहीं होगा कि एग्जाम में कहीं आपको लगे कि सर ने ये चीज नहीं पढ़ाया, और ऐसा भी नहीं पढ़ाऊंगा कि सर ने सब कुछ पढ़ा दिया है, क्योंकि कुछ बाकी रहना चाहिए। तो वो आप अपनी तरफ से एफर्ट लगाएंगे। तो आप लोग भी अब आ गए हैं, फोर्थ ईयर में आ गए हैं ना जी आप लोग भी। तो
हाँ सर।
फोर्थ ईयर वाले बच्चे थोड़ा तो एफर्ट लगाएंगे, फाइनल ईयर वाले बच्चे थोड़ा ज्यादा लगाते हैं, इसीलिए एनओसी पे चले जाते हैं। तो आप लोग कम से कम थोड़ा एफर्ट लगाइए। बाकी किसी को कोई क्वेश्चन है तो पूछिए।